co-authored an amicus brief in this case for the Cato Institute. Professor Blackman graduated from George Mason University Law School and clerked for Judges Kim Gibson of the U.S. District Court of the Western District of Pennsylvania and Danny Boggs of the Sixth Circuit. Professor Brian Fletcher will then respond. Professor Fletcher is an associate professor of law and a co-director of the Stanford Supreme Court Litigation Clinic. He is an experienced appellate litigator, previously serving for 5 years as an assistant to the Solicitor General of the U.S. Department of Justice and arguing multiple credit cases before the Supreme Court. He also has authored an amicus brief in this case with the Supreme Court Litigation Clinic for 32 healthcare policy scholars. He also worked in the Obama White House on issues related to the implementation of the ACA. Professor Fletcher attended Harvard Law School and clerked for Judge Merrick Garland of the D.C. Circuit and Justice Ruth Bader Ginsburg of the United
Yeah. Blessed memory. Yeah.
Absolutely. Before we begin, I'd like to thank Professor Fletcher in particular for participating in this panel in a week that I'm sure was emotionally and logistically difficult. Stanford Fellow Society would like to express our condolences to you and all of Justice Ginsburg's friends and family, and we've certainly been thinking about you during this difficult week.
I appreciate that. Thank you.
Yeah, I mean, the same here. I'd forgotten you clerked for Justice Ginsburg. Thank you so much for coming today. That must be really, really tough.
Thank you. So we'll reserve time for questions after the speakers have concluded their remarks. Please submit text questions via the Q&A function in Zoom, and I will read them to speakers during that time, using that as opposed to the raise hand function. So please join me in welcoming Professors Blackman and Fletcher.
Okay, thank you so much to Stanford and Professor Fletcher for having me, especially this is such a surreal time for those who follow the Supreme Court closely. There are just so many things going on at once, and not all of them are good. Many of them are quite painful. So it's I hope we can at least bring you at least a moment, maybe an hour, to focus on a legal issue, even though we're amidst this turmoil in the world around us. So thank you so much. And Nick, appreciate you having me. We're back talking about Obamacare again for the 1 millionth time. My first book on the ACA came out in 2013. I spoke at Stanford Law School then. Those people are probably clerking in the Supreme Court by now. I came back in 2016 for my second book on Obamacare. And now I'm working on a third book on Obamacare. This is the law that keeps on giving. My goal today is to walk you through the history of the law as it relates to the current case, California against Texas. I will not even attempt to go through every facet of the law because it's just far too complicated. Our story begins in 2010 when Congress enacts the Patient Protection and Affordable Care Act. This was a landmark piece of legislation that did a lot of very important things. Perhaps one of the most popular aspects of the law was it created regulations to protect people with what are called pre-existing conditions. There are two primary regulations, guaranteed issue and community rating. I'll just call them GICR for short because it makes my mouth less likely to skip over it. With GICR, policies were priced not based on a person's health, but based on their age and where they lived. Moreover, the insurance companies had to issue a policy. They could not deny coverage to a person based on any sort of conditions. Okay. Now, this was a revolutionary change in healthcare policy because before this, the federal government really had no input on this issue. But the government recognized that this might be a risky approach to having healthcare. Why? A person could choose to free ride. They could simply wait till they got sick and then purchase a health insurance policy. And the thinking went, this would leave only sick people in the healthcare pool and healthy people will stay outside the healthcare pool. So some states had experimented. For example, Massachusetts, Governor Romney implemented a policy in a state known as the individual mandate. This was, as the name suggested, a mandate to buy insurance. This was actually a conservative idea proposed first by the Heritage Foundation in the early 1990s. If someone failed to buy insurance in Massachusetts, there was a penalty to be paid. Okay. The ACA more or less adopted that approach. And I'm going to make this point very clearly. the law doesn't actually say individual mandate. That phrase doesn't appear anywhere in the statute. I think we can all be honest about that. It says it creates a, quote, requirement to maintain minimum essential coverage. The court called it the mandate, so that's what I'm going to call it, but we should just be clear that the law itself doesn't have a mandate. Okay. That's one provision of the ACA. Another provision of the ACA is called the Shared Responsibility Payment, which is known as the penalty, but that's not how it's called in the statute. A person who does not comply with maintaining minimum essential coverage for some periods of time has to pay this penalty. It was about $700 and would fluctuate over time. The amount actually isn't terribly important. I'm sure, as you all know, almost immediately after the ACA was signed into law, lawsuits were filed across the country in almost every circuit. Eventually, this case made its way to the Supreme Court from the 11th Circuit appeal. The Supreme Court, I will quote Justice Ginsburg, left the ACA relatively unscathed. Brian, I get that right? I think that's the verbatim quote. I think she's right. The ACA largely survived the Supreme Court's buzzsaw. There are some tweaks which are important, but I want to just say at the outset, the case more or less held up the ACA. Now let me walk through the components of the decision, NFIB versus Sebelius. Okay. First off, the case is called NFIB, which is the National Federation of Independent Business. But to be frank, NFIB didn't really have standing on their own. Their standing was premised on members of this organization. One woman named Mary Brown and a guy named Kai Alberg. Who are they? Their names are not in the caption, so you don't know who they are. They claimed that they were injured by the individual mandate. More specifically, they said, we're going to have to buy insurance in a couple years, and we don't want to buy this insurance, so we want to sue. Again, they planned to comply with the mandate. They were never going to pay the penalty. Their only injury was what was called a pocketbook injury, which was being forced to buy insurance. The government never really contested the standing of the individual plaintiffs. They didn't. Initially, they did it briefly, but they dropped it. They challenged the organizational, but the individuals, I think they said, had standing. That was pretty well established. Okay. So then we get to NFIB. And the Chief Justice's opinion is controlling. And it has three main parts. And unfortunately, I have to give you the letters. Parts 3A, 3B, and 3C. I know it sounds silly, but this actually does make a difference. The first part of the opinion, Part 3A, held that the mandate, this requirement to buy insurance, cannot be sustained under the Commerce Clause, and it cannot be sustained under the Necessary and Proper Clause. First, Congress can't force you into interstate commerce. That's a no-no. And second, the Chief says this law is not a proper exercise of federal power. This was basically McCulloch v. Maryland, if you want to go back old school. Then we go to Part 3B of the controlling opinion by the Chief Justice. And in Part 3B, he says that this mandate cannot be sustained under the taxing power. He says it's not a tax. It wasn't designed as a tax, and it's not best read as a tax. Okay, that's 3B. But then we get to 3C, and this is the one that makes me pull my hair out every time I teach it. Part 3C is where the Chief develops and applies the so-called saving construction. If you haven't heard this phrase before, a saving construction is a way of reading a statute that may not be the best reading of the statute, but that avoids some constitutional problems. In other words, if you read it in the first option, it's unconstitutional. And if you read it in the second option, it becomes valid. So even if the second reading is perhaps not as good, not as persuasive, not as coherent, you sort of pick the one that upholds the statute. And that was the sort of nature of where the Chief Justice was coming from, that courts have this unflinching duty to try to save statutes. Okay. So in Part 3C, Robert says that, look, it's not actually a tax, but the penalty that the AC imposes, quote, looks like a tax in many respects. And that's an important phrase. He says it looks like a tax in many respects. So, for example, the penalty raises revenue. It's paid to the IRS, right? It comes on your annual tax return. If you don't pay it, the IRS can withhold it from your future tax returns. They can't use collection. That's actually one of the quirks of the law, right? They can't like put a lien on your house or something. They just withhold it from future refunds. So the chief says, in many regards, it looks like a tax. Then he makes a move that I think is not well understood. People say, oh, the Chief Justice upheld the mandate as a tax. That is not exactly correct. That's not what he did. He didn't uphold the mandate as a tax. He said, I'm looking at this statute, what's called Section 5000A, right? And I'm going to view it as a single entity, that the mandate and the penalty are fused together, right? That these are not separate provisions. I'm going to fuse together the mandate and the penalty so that there is no mandate. Rather, people have a lawful choice to do or not do a certain act so long as you pay a tax, right? So Roberts didn't uphold the mandate as a tax. People say it all the time. It's simply not accurate. He fused together the mandate with the penalty and said we can read this sort of fused provision as simply imposing a tax on doing or not doing something. You have a lawful choice, right? Again, this is in Part 3C of the opinion, which was based on the saving construction. I view the saving construction as something of a gloss on the ACA, right? This wasn't the best reading of the statute. It wasn't the statute itself, but it was this sort of fused version, this alternate reality, a reading that led to the law being upheld. Roberts repeated that the most straightforward reading of the mandate is that Section 5000A commands individuals to purchase insurance. Again, the most straightforward reading is a command to buy insurance. The shared responsibility payment as directed was not a tax. It did not offer a lawful choice. It imposed and imposes to this day a mandate to buy insurance. But because of this saving construction, you can read it differently. All right, that was a huge windup before we get to the present. Okay, so that was 2012. The ACA chugged along, ups and downs. Go read my book if you want to read about it. But then we get to 2017. The Republicans tried mightily to try to repeal Obamacare, which was never going to happen. John McCain famously gave the thumbs down. Remember that one? I'm sure Cindy McCain was thinking about that one yesterday. But they were able to enact this tax reform towards the end of the year, I think in December of 17. The Tax Cut and Jobs Act of 2017, the TCJA, tooth and mouth jaw, it sounds an awful acronym. The TCJA. All right. Now, this bill was passed through something called the budget reconciliation process, which, to summarize very concisely, when you do certain financial moves in the Senate, you're not subject to the filibuster. That's the simplest explanation. So they were able to do certain financial changes without needing to get 60. They only needed 50 because they didn't have 60, that's for sure. And they were able to modify only one specific financial portion of the ACA. Using the procedure they picked, they could not modify the mandate. They weren't even allowed to, right? The only part they could modify was the shared responsibility payment. And they couldn't eliminate the statute. They couldn't repeal the statute. All they could do was change the dollar amount. So they basically changed the dollar amount from at $700 to $0, right? That's all they did. They didn't touch any other aspect of the Section 5000A. They just dropped the penalty to $0. So when this happened, I was thinking, I wonder if someone's going to sue. I started thinking, this is depriving people of the saving instruction, right? This is going against what the chief said. And lo and behold, Wisconsin, Texas, and a number of other red states followed a lawsuit. Like me, candid, they picked the Northern District of Texas because it's a very favorable forum. I think most litigations, by the way, this is for you future lawyers, forum shopping is rational. If you're not forum shopping, you commit malpractice, right? You should file where it's best for your client, whether you're a governor or an attorney general or a law firm. I just don't get this argument. It's whatever. But they filed in Northern District of Texas, and they got a favorable forum. And here was the argument. Section 5000A can no longer be read as offering people a lawful choice, right? By rescinding the revenue raising component, you basically strike out Part 3C of the opinion. Again, you have 3A, which was commerce, necessary and proper, 3B saying it's not a tax, and 3C saying it can be upheld as a tax under the saving construction. But once you kick out the revenue raising function, Part 3C is out the window, right? You're left with 3B, which says it's not a tax and it's unconstitutional, all right? That's the merits question. And I don't expect we'll have much debate about that. I think actually that's one of the easier parts of the case. I think the hardest part of the case is actually the first step, which is standing. And I'm sure Brian will be happy to talk about this with me in a few minutes. The standing argument, I admit, is kind of weird. It's so unintuitive that people just think this has to be wrong. And I need to brace you before this. The standing argument here was largely resolved in 2012. You say, Josh, how could that be? In 2012, there's a penalty. Okay. The way the case was litigated in 2012 was based entirely on the mandate. And this part simply is just not well known. And maybe because I've written books on this, I'm steeped in it. But I've always understood implicitly that this case was never about the penalty. How do I know this? The plaintiffs in that case said that they would not ever pay the penalty, that they were law-abiding citizens, and that if there was a mandate to buy insurance, they would comply with it. The reason why they were able to sue in 2012 was because they had to make preparations to buy insurance in the future. At the time, there was no mandate. It wouldn't kick in until, was it 2014 or 2015? It was still a couple years away. So the only basis for the injury in fact in 2012 was the mandate, right? Nothing has changed. If you go back and you read the oral argument transcript from the NFIB case, there was a colloquy between, now Judge Greg Katsas, who's a judge in the D.C. Circuit. He was a lawyer at Jones Day. Between Judge Katsas, I'll call him Greg, between Greg Katsas and Justice Roberts, Chief Justice Roberts, and Justice, I think it was Kagan. And they're basically talking about whether there will be standing in the absence of a penalty, right? That if there's no consequences for going uninsured. And Chief Justice Roberts said, what if you had a toothless mandate, right? A toothless mandate where nothing happens. And then Katsas replies, well, because Congress might think that people will comply with the mandate because it exists. And there's a CBO report that says people will buy insurance if there's a mandate, even if there's no penalty. Now, Roberts, I admit, was skeptical of this argument, but he would have had to accept it. If he found that there was no injury in fact based on the mandate, he could not have gotten past the go. He couldn't have written the opinion. The opinion had to rely on the fact that they were standing based on the mandate. There was never any allegations in the face of the complaint that the penalty would play any role. And that was never the theory of the case. If I'm right about that, and huge if, the chief always likes to surprise me in June, right? If I'm right about that, then the standing inquiry is actually not the hardest part. It's the most unintuitive part, but I think it's the easiest part. Okay, that's part one, standing. California argues vigorously, that this is a toothless mandate, that there's no injury, you can't sue to challenge it. And I don't think that's going to work. I think you're going to have troubles with the history of this case, and the justices know this history well. But we'll see what happens. Okay, that's part one. Part two is the merits question, if you want to call it the merits question, right? If the revenue is dropped to zero, does the saving instruction still apply? I think California wisely spends very few pages briefing this question because they know it's not that important. I think they'd be okay if the court says they're standing and the mandate's unconstitutional and nothing else. I think they say, okay, you got me, right? You got me, whatever. Move on with our lives. So there's some arguments to the contrary. In fact, one I find so devious, I'm worried about it because I think the chief might accept it. Not everyone pays their taxes on time for legal and non-legal reasons, right? There are some people who owed a penalty in 2017 that never paid it, right? And maybe they'll pay it in 20 years when they finally get around to it. So in theory, at least, this provision still technically raises revenue, right? It might just be a very small amount spread out over decades. I can see the chief saying, well, it's still raising revenue. There's no minimum dollar. It's not like a $75,000 one penny controversy. It's revenue. Now, I don't think that works because the Chief's saving construction was not the sort of balancing, accounting exercise. I can't see it, but he's proved me wrong before. All right. But the ball game is on the third question. This is really where everything turns, which is severability. Severability. Texas and the individual plaintiffs argue that if the mandate goes, the entire ACA must fall. This was the position adopted by the Obama administration. I'm sorry, I misspoke. I'm sorry. This was a position adopted by the joint dissenters, by Scalia, Kennedy, Thomas, and Alito. Right? They argued that because the mandate was unconstitutional, the entire law must fall. There's a more middle ground position, which is what the Solicitor General took in 2012, Don Verrilli. Verrilli argued that if the mandate fell, you would also have to strike down the GICR, the Guaranteed Issue and Community Rating. That is, Congress never would have wanted to have this these generous protections for sick people unless it was a mandate. That was the Obama administration's position in 2012. Okay. Initially, Jeff Sessions argued the Obama position that if you kill mandate, you have to kill GICR as well. But they changed positions, and exactly how they changed positions is not well understood. Let me take a step back. The Supreme Court is in a state of flux right now on severability. And this is not a left-right issue. Among the court's depending on your count, but among the court's 5 conservatives, standing is not a clean issue. We've had a couple cases in the last years to illustrate this. The first was Justice Thomas's opinion in Murphy versus NCAA, which involved online sports gambling. And the question was, if part of the law is invalid, what happens to the rest of the law? And Thomas says, wait a minute, we're courts of limited jurisdiction. Only if you have an injury can you get into this court, right? But how can we strike down parts of a statute where the plaintiff can't claim an Article III injury? I was persuaded by Justice Thomas. I hadn't thought of it before, but CT's got a point. But now CT's brought Gorsuch along. So we had a case last term called Fbar versus with the American Association of Political Consultants, AAPC. And the Fbar case held that this regulation of robocalls, not important, was unconstitutional. Okay? But then the remedy. The majority was by Kavanaugh. The Chief joined it, as did Alito, which used a sort of traditional, intentional approach to severability, where you sort of look at what Congress would have intended. And the Thomas Gorsuch approach was, no. We don't strike down anything. We simply just enjoin it in this case. Yes, Thomas and Gorsuch and Josh think that courts shouldn't be striking down statutes. Just issue a remedy in this case. This was repeated in Sela Law, which was a CFPB case, where the majority held that we just strike the for-cause provision. But then Thomas and Gorsuch came out and said, no, we simply just say in Sela Law we can enforce the judgment against them. Kagan shrewdly joined Roberts in the majority to give 5 votes there to make sure this wasn't an influx. He's very shrewd like that. So I'm telling you, the severability doctrine is not what you think it is. I don't know if this is the appropriate case for the court to sort of draw a line in the sand. I think it's actually a terrible case to do it. But I don't think we can just say it's settled doctrine. No, this area is in flux, my friends. This area is in flux. So let me give you the bottom line. I don't agree with Texas. I don't favor complete invalidation of the ACA. I think that's not going to happen. In fact, I don't think Texas actually believes that. Like, they might say it, but they don't really believe it. I don't think the Obama position in 2012 is going to work. The sort of, we just sever out, mandate GICR and let the rest of the statutes save and stay alive. I don't think Gorsuch and Thomas go for that. In other words, I don't think there are 5 votes for the Obama position. There might be 3. Probably 0, but not 2. Thomas and Gorsuch won't go along, which led to the Josh position, or what I developed with Cato, right? Which is, I admit, a bit idiosyncratic, but I'm trying to read the tea leaves. I'm trying to see where Thomas and Gorsuch are going and see if I could craft something to bring the Chief, Roberts, and Alito along. And who knows, maybe Justice Amy Coney Barrett, maybe I'll have a 6th vote. I didn't anticipate that when I wrote this brief, but why not? Here's the argument. The injury that the two plaintiffs claim is that they are being forced to purchase an unwanted product, right? That's their injury. They don't want insurance that's encumbered by these various regulations that makes it expensive. They would want to buy, a bare bones emergency catastrophic policy, or maybe none at all. Okay, let's just assume I'm right for a moment that the mandate's unconstitutional and GICR can't be severed. Just assume for a minute I'm right. I'm not, but just assume I am. In that case, I think it'll be overbroad to destroy GICR for all Americans who do not claim an injury. I think it's way too overbroad. Why are you killing a program that is only injuring a small number of people? If people aren't claiming an injury, then you shouldn't destroy the program for them. So what I would propose is a narrow remedy. A narrow remedy. And it doesn't even have to be an injunction. A declaration would suffice. A declaration that as applied in this case to these two plaintiffs, you cannot enforce the GICR policy. Right? And how would this actually work in practice? You leave the Obamacare exchanges as they are, right? If you're going on a government exchange to buy insurance, you can't complain. I'm sorry, you can't complain. But if someone wants to buy a policy off the market, these two guys, they're two Texans, if they want to buy a policy off the market, the GICR regulation should not be enforced as to them. Josh, are you saying we're litigating this entire case for two people? That's how litigation works, my friends, right? Unless you have a class action, which is and I think we can certify here very easily, but unless you have a class action, remedies should be limited to the parties at issue. Farewell nationwide injunctions, farewell global, universal, cosmic, whatever, I can't remember. The universe keeps expanding, right? I don't like non-party injunctions. I don't, maybe they're constitutional, I don't want to get into the debate, but I don't like them. We shouldn't have them. I want to do what Gorsuch and Thomas did in Sela Law and issue a remedy for the one company. I want to do what Gorsuch and Thomas did in the Barr versus AAPC case, which is issue a remedy for this one organization. Now, if the court issues a remedy I requested, I think the government would likely say, okay, maybe we should stop enforcing this more broadly. And they can comply voluntarily, not by force, but voluntarily. I also think a class action would work. You certify a class of all people who claim an injury, and they're exempted from the GICR policies. So in other words, people who like their Obamacare policies can keep their Obamacare policies. There it is. I saw Brian smile. And those who don't, see, I'm flipping on Obama, right? And those who don't can go off the policy. I think this would have some disruption, perhaps, but it would be far less disruption than anything along the lines of what Texas is arguing. But again, I realize the severability issue is in flux. I don't know where the court is. In fact, my last statement, I'll shut up now to give Brian some chance to respond, is if Judge Barrett or someone else is not confirmed, I think we go 4-4. And the court just 4-4 says, whatever, affirmed by an equally divided court, send this back to the district court and talk to us in 2 years. Because that's how long it's going to take on remand. Because there's no injunction in place. So all this litigation, all of the briefs which Brian and I wrote might yield a one-sentence affirmance, 4-4. Lord help us. It's like the Little Sisters of the Poor case. Come back in a couple years, see what happens. Yeah, but who knows? All right, I'm going to stop here. Thank you so much. I appreciate your attention on Zoom, and I look forward to this discussion.
Thank you, Mr. Blackman. Professor Fletcher, I thought you were responsible.
Thanks very much. Thanks to Nick and the Federalist Society for hosting this, and thanks very much to Josh for his remarks. Can you guys hear me okay?
Mm-hmm.
Excellent. Okay, great. I think Josh has done a great job of setting up for you the history of the statute, and I think hopefully I think we're going to have some lively disagreements, because I actually think the merits of this case are very easy in the other direction. I think California ought to win, and I think that the Texas theory on the merits doesn't make a whole lot of sense. And then I'll talk a little bit about severability too. And I guess the way that I would suggest thinking about the case is by starting with the question of statutory construction and asking what does Section 5000A mean? Because if it means what Josh and what Texas say it means, it's a legal requirement to have insurance, then everybody agrees that then there's probably standing. The standing question is still hard, and California has arguments, but probably they're standing to challenge that sort of requirement. And everyone agrees that it's unconstitutional under NFIB. On the other hand, if Section 5000A, as amended in 2017, doesn't impose a legal requirement to have insurance, then I think The standing argument for the challengers gets much harder. I think they probably don't have standing. Maybe they can come up with some theory. And I also think the merits argument gets very easy. I don't think that anyone thinks that there's a problem with Congress passing a law that says that you should either have insurance or you should pay a tax of $0 just to save you nothing at all. I don't know. I don't think that's an unconstitutional provision, although maybe Josh disagrees. I'll be interested to hear that. So how to think about that? I guess if you'll bear with me, I'm going to try to share my screen. Maybe this works. Looks like.
Do you have permissions?
I think it's going to let me do it.
Yeah, there we go.
That worked. Excellent. Okay. So this is just giving you the text that Josh talked about, but I find it easier to talk about this because it is a complicated law with the text in front of us. So this is the individual mandate, Section 5000A, as it was before 2017. And I've simplified it a little bit. I've taken out the titles. I've done some ellipses, but everything here that's not in brackets is actually in the text. And just as Josh said, you have this subsection A, which looks a lot like a legal requirement to have insurance, right? It says every individual shall ensure that that individual is covered under minimum essential coverage, ACA health coverage. All right, then you have section B, that's the consequence. If you're not covered, there's thereby imposed a penalty in the amount determined in subsection C. And subsection E is a holy mess. I haven't tried to give you the whole thing, but the main point is there's sort of two inputs to the amount of the penalty. One is a percentage of your income, and one is a flat dollar amount. And so I've given the percentage of income here was 2.5% after 2015, and just as Josh said, the penalty, the flat dollar amount was about $700. So the first main event that happens with this version of the statute is that it gets to the court in an FIB. And I might quibble a little bit with some of what how Josh described the Chief's opinion, but I think he got the bottom line exactly right. I think that the Chief said, if we look at this statute, boy, it sure looks like a legal requirement to have insurance. There's the shall word up here in A, there's this penalty language. So the Chief says that's the most natural way to read the statute. But he and four other justices say that if it did impose that sort of requirement to have insurance, it would be unconstitutional. And so the Chief says, we can read it, it's susceptible of being read not to do that, and instead to just be a tax. So under the reading that the Chief adopts, you can say it's an application of canon of constitutional avoidance, you can say it's a saving construction. The bottom line is that word that Josh gave you that's in the Chief's opinion. As construed by the court in NFIB, this provision gives individuals a lawful choice. You don't, notwithstanding the shall in subsection A, you don't have to buy insurance. The court says you can choose. You either buy insurance or you pay a tax of 2.5% of income or $695. So that's where things stood after 2015, or after NFIB, excuse me. And I'll say that was controversial. A lot of people, I suspect Josh was probably among them, disagreed with the Chief that you could read the provision that way. A lot of people thought you could read it any way other than as a penalty. But the Supreme Court settles that, at least as far as the pre-2017 version of the statute was, and sort of authoritatively said, notwithstanding the shall, this gives people a lawful choice. So then Congress in 2017 revisits the ACA. Now President Trump is in office. Now Republicans have a majority in both houses of Congress. And just as Josh said, in the summer of 2017, there was a big high-profile effort to repeal the whole ACA, or if not the whole ACA, at least big chunks of it. And all of those efforts failed. As Josh said, I was going to say the same thing. That dramatic moment late on the Senate where John McCain came in and signaled his decisive negative vote with the thumbs down, and that meant there weren't 50 votes to repeal the ACA. And instead, just as Josh said, in a tax bill, a big tax bill, the sort of Trump tax cuts bill that the Senate passed in that fall, there's this one little provision, and this is, I could put the whole thing up there actually from the statutes at large because it's so short. This is the whole thing. This is what we're fighting about, is this change to the law. And so I'm going to give you now what the law looks like today. And I've put in bold and underlined the things that were added in 2017, and I've struck out the things that were deleted in 2017. So just as Josh said, the penalty amount goes from 2.5% to zero, and the flat dollar amount goes from $700 to nothing. All right. So now we've keyed up the statutory interpretation question. There's two ways to understand what the 2017 amendment did. The Texas view, and I think I understand Josh's view, is they reopened the whole question of what does this statute mean. They said they threw open the question of what does subsection A mean. They upset the construction adopted by the Supreme Court in the FIB, and in so doing, they reimposed or they imposed for the first time, since the Supreme Court said it wasn't a mandate before, a legal requirement to have insurance. There's another way to understand things, though, and that is to say that the Senate and Congress, when it acted in 2017, took for granted the Supreme Court's construction of the statute. Understood and assumed that even though it has this word shall up here, it doesn't really mean shall. It gives people a lawful choice between having insurance or paying an amount, and they just reduced the amount to zero. And on that understanding of what Congress was doing, it was effectively repealing the individual mandate. It was saying, now you have a lawful choice between having insurance or paying $0, which is to say nothing at all. And so the provision remains on the books for exactly the reason that Josh said they couldn't remove the whole thing through the budget reconciliation process. But it has no legal effect. It doesn't impose any legal obligations on anyone, and certainly doesn't legally require you to have insurance. Now, that's the debate between the parties on the merits. I think that the most natural way to understand what Congress did in context is the latter version. And I think that makes the most sense because of the usual principle that when the Supreme Court has authoritatively construed a statutory provision, you assume that Congress doesn't intend to change that unless it speaks pretty clearly on the question. And I don't think you see Congress speaking clearly on that question here. To the contrary, they don't change at all this provision of A that the court had already interpreted not to impose a mandate. They just reduced the amount of the penalty. So I think that's the most natural reading, but maybe you're not persuaded by that. And if you're not persuaded by that, I think there are two other arguments that ought to persuade you. And the first one is the same thing that the court relied on in NFIB itself, the canon of constitutional avoidance. The idea that if there's any way to read a statute, any possible way, even if we have to squint and bend the statute a little bit to make it constitutional, we should do that. Here, everyone agrees that if you interpret the 2017 amendment as transforming this into a mandate to have insurance, then it's unconstitutional. So if there's any possible way to read the statute as amended in 2017 not to do that, we have to do that. I think that's a powerful reason to read it my way as just an effective repeal of the provision. And the other reason is legislative history. And legislative history is sort of a dirty word in the court right now because, as Justice Kagan said, we're all textualists now. And I agree with that. I believe that. I think some justices are still willing to look at the legislative history if the text is ambiguous. And I think here the legislative history is incredibly powerful because everyone involved in the passage of that provision, from this Senator McConnell on the left saying we voted to repeal Obamacare's individual mandate tax, this is Speaker Ryan on the right saying we repeal the individual mandate at the heart of Obamacare, and this is President Trump tweeting on the day he signed the bill that the individual mandate is terminated. And he said this, he does this all the time, even when the Solicitor General was in the Supreme Court saying the opposite. And believe me, this is just the tip of the iceberg. Everyone who voted for this bill said what we are doing is eliminating the individual mandate because people don't like the individual mandate. No one suggested that what they were doing was imposing an individual mandate, and it would have been nuts for them to do it because everyone who was supporting the 2017 amendment were the Republicans in Congress who had been railing against the idea of a legal mandate by insurance. Heck, most of the senators who voted for this bill had signed a brief in NFIB saying that such a thing would be unconstitutional. So I understand that the court is often not eager to look at legislative history, but I think even a really dedicated textualist should be hesitant to read a statute to do exactly the opposite of what all of the people who voted for it and signed it are telling the public they were doing on such a high-profile issue. So that's why I would read the 2017 amendment as just a simple repeal. And I think maybe there are interesting questions about what requirement to have insurance or pay a tax of $0 is constitutional, but I think there's a pretty good argument that it is, and certainly doesn't run into the NFIB problem. I'll just say a quick word on severability, which I think Josh is right when he says that there are a lot of interesting currents floating around in the court on severability now. I will leave it to Josh to talk about the Thomas and Gorsuch approach and how that could lead to some sort of interesting wrinkles here. And I'll confine myself to the approach that has commanded a majority, although not a uniform majority, which is to say, we ask, if a provision of the statute is unconstitutional, we keep the rest unless it's evident that Congress wouldn't have wanted that part of the statute without the invalid part. So in other words, the question is, would Congress have preferred the ACA without the individual mandate if it is in fact invalid over no ACA at all? And my short answer to that question is that if you frame the inquiry that way, and I understand that that's contested, but that's the way that the Chief and Justice Gorsuch and most of the other members of the court do right now, then I think this is an unusually straightforward case. Because we know from 2017 that the Congress did not want no ACA at all. Some people tried to get that, and they couldn't in a very high-profile effort, and that failed. And instead, what Congress did was eliminate any legal consequence for not having insurance. Everyone agrees, even the people who now read it as a legal requirement to have insurance, I think concede that there's no consequence for not having insurance. So Congress has already effectively given us an ACA without the individual mandate because they've rendered it completely unenforceable, which is the only thing that the court could do if the court declared the law unconstitutional. And I think when Congress has already given you the same statute that you would have if the court declared that this provision was unconstitutional and therefore unenforceable, that's pretty strong evidence that that's the statute that they wanted, and that they certainly preferred that over no ACA at all, or an ACA without the extremely popular and important guaranteed issue community rating provisions that Josh talked about. So that's my spiel. Love to answer your questions.
Thank you. Thank you so much, Brian. That was excellent. And I think the students at Stanford are very fortunate to have you and Jeff and Pam and all the other wonderful attorneys you have at the clinic. So I'm deeply grateful for your time, especially this time of the year. The key words in this case are lawful choice. Lawful choice. I think those are the most important two words in the entire opinion. I will concede if Brian is right about this lawful choice language, then my argument falls pretty quick. I'm happy to concede that. I don't think he's right, but I'm happy to make that concession. I've been arguing about this lawful choice point for nearly 8 years. 8 years. So this isn't new for me, right? For a lot of people, it's like, oh my gosh, where's this coming from? I have an entire chapter in my book published in 2013 about this lawful choice language. An entire chapter. I could not have foreseen that this chapter would be relevant, in this context. It was unforeseeable because I've been arguing about this for years. What is the best way to read Part 3C of NFIB? Right? What's the best way of reading it? Randy Barnett, my colleague, and I have reading it this way for 8 years. So at least we're consistent. If nothing else, we've been doing this before it was even relevant. So that's why I have a commitment to it. But I want to turn now to Part 3D of the Roberts opinion. And this is a very important part of the opinion. I encourage you to read it. And it's important because Chief Justice Roberts engages with the Justice Ginsburg opinion, which is kind of a dissent. Not really. I'll just say the Ginsburg opinion to make it easier. Ginsburg says, why do you have these three parts of your opinion, right? If it's a tax, why do you need to have all this dicta about the Commerce Clause, right? Why are you trying to lay a marker on commerce necessary and proper if this is a tax? And Ginsburg calls it, I love this line, she calls it a Commerce Clause essay, right? Why did the chief write this essay in the Commerce Clause if this is just a tax? And then Roberts responds and notes that Ginsburg is not correct. He can only reach Part 3C, the saving construction, by rejecting the commerce necessary and proper arguments, and I would add, by rejecting the government's taxing power arguments. Right? At least one judge in the Fourth Circuit upheld the penalty as a tax. One judge did, and he rejected it. He rejected that opinion. And Roberts repeats that the statute reads more naturally as a command, not as a lawful choice, as a command. Quote, it is only because the Commerce Clause does not authorize such a command that it is necessary to reach a taxing power argument. Right? The predicate is that the statute is not actually affording people a lawful choice. Okay, so then Ginsburg responds, because she never backs down, not for a second, we'll give an inch. And she says, but so what? If it's fairly possible, that's the word, a fairly possible construction, right, then why do we need this Commerce Clause analysis, right? And then that's the point Chief Justice Roberts explains. He responds to Ginsburg. He says, we can only reach Part 3C after fully considering and rejecting the necessary and proper in Part 3A, right? You only get to the saving construction because it's not a lawful choice, right? And I would add, you only reach Part 3C because it's not a tax. So this lawful choice language is only in existence in this sort of bubble, this gloss of Part 3C. It's the only place it exists. And if you cut off, if you may sever Part 3C from the opinion, you're left with 3A and 3B. And that's why I think the merits are quite easy, right? Because the court already resolved what happens if a mandate by itself is unconstitutional without regard to the penalty. Roberts doesn't mention the penalty anywhere in 3A and 3B. It's all about the mandate. You only get to the penalty towards the end as part of the saving instruction. Now, maybe I've read John Roberts' opinion too many times, right? I think I have. God, Lord tell. I mean, I've read it many times. Maybe I'm seeing spots, it's like a Rorschach test. I see what I want to see. Maybe the chief will say, no, that's not what I meant. Professor Fletcher's position was correct. Maybe the court will say 4-4, we're not going to tell you a damn thing, which is what I expect will happen. But this question of whether the lawful choice exists in 3C or it exists throughout the entire opinion, that is things where the merits question turns. And I will concede if my reading's wrong, okay, I'm wrong. I think Mike Dorff and Marty Lederman have a brief that he's not SG anymore, but Don Verrilli is now private practice. He basically cites the Dorff-Lederman brief over and over again. I think if you want to see the opposite perspective of mine, go read the Dorff-Lederman brief. It's very good. I think we were about to cite them, but we ran out of words, so I just cut the citation. Words really matter in a brief when you're at the limit. But they take the opposite position of me, and I think the entire case turns on the phrase lawful choice. And I will be happy to eat my words if I'm wrong about this. Thank you so much.
Thank you both. That was fantastic. I'll bring you some audience questions. The first question is, what in the text of the statute makes the penalty a saving construction rather than a natural reading?
Mm-hmm. Put
another way, how could the statute have been written differently to make the chief's reading in 3C a more natural reading?
That's a good question. And Brian, if you want to jump in, you're welcome to as well. But I think what Robert says is that the penalty cannot be construed. I'm sorry, the section 5008 cannot be construed as a tax because, for one, it doesn't use the label tax. It's written in a very peculiar fashion. I think actually here's a case. They looked at legislative history. A lot of members of Congress said this is not a tax. President Obama said it, and many leading senators said it. Had Congress just come out and said, we are imposing a tax on going uninsured, this case would have been over very quickly. If this was just a payroll tax, like I think of like a Medicaid or Social Security tax, this case would have been easy. So I think here Congress tried, they tried to do something, how do I put this casually? They didn't want to have the political fallout of calling it a tax because the political situation was very precarious at the time. So they tried to sort of finagle it. But there were some smart lawyers saying, you need to make this look like a tax, right? So there's some fishy history there. Brian, anything you want to add at this point?
No, I think that's about right. I think that there were definitely some sort of line drawing to thread, and I think the chief's opinion sort of lays out the things that suggest that it's not a tax, that it's got this word shall attached to it. That's unusual for a tax, to say the least, and it's called a penalty. And there are people who are subject to one but not the other, which sort of suggests that the Part A is doing something other than just being the predicate for the penalty imposed by Part B. But he also says he has a sort of on the other hand, it's not just constitutional avoidance. He also points out that Congress sort of fully understood that lots of people weren't going to get health insurance and were instead going to go without and pay the penalty. And he said we're sort of reluctant to conclude that Congress casually turned millions of Americans into lawbreakers. And so that was one of another consideration he pointed to supporting the tax construction.
Yeah, very good. Thank you.
Thank you. The next question is, do you think the Supreme Court will examine the intent of the 2017 Congress rather than the 2010 Congress that originally passed the law in determining severability?
Oh, yeah. Well, I didn't get into this question in my opening remarks, but I'll be happy to answer it here. I actually agree with California on one issue. If Congress is looking at the intent of the 2017 Congress, I think you just sever the mandate and you go home. And I've said this publicly. I don't think the 2017 Texas tries to argue that the 2017 intent is a little bit vague. I'm with Brian in California. But I don't think the 2017 Congress is one that controls here. And my argument here is a little bit unconventional, shall we say. There's an old case called Frost versus Oklahoma Corporation Commission. It's a case from the 1920s. If you've never heard of it, you're join the club. And the case goes like this. A legislature enacts a statute that's constitutional. Later in time, another legislature amends the earlier statute, and the amendment renders the earlier statute unconstitutional. So what's the remedy? Do you strike down the entire statute? No. Frost says you strike down the amendment. Huh? Right. In other words, you remove the thing that created the unconstitutional condition, right? It was perfectly fine. Everything was cool. And then you screwed it up. So you remove the thing that screwed things up. What would that mean here? if this Frost case controls, you strike down the tax cut, right? You restore the penalty. This is basically what Brian said before. If you want to make this law constitutional, you just restore the penalty again, right? I mean, of course you could do that. Look, in my mind, that would actually be the correct remedy, which I think is not popular in this. What I'm saying is not something I want, but if in fact it's the case that the 2017 tax cut rendered the ACA unconstitutional, then the remedy is to kill the tax cut. Now, that would be a logistical nightmare. But I don't think that's an option here, and let me explain why. Under the Thomas Gorsuch approach, courts can't willy-nilly strike down provisions in the U.S. Code. You can only strike down provisions that injure people. And no one here is injured by a tax cut. California sure is not. Maryland actually argued in one of the, this was Tom Goldstein's litigation, Maryland argued that the tax cut should be killed. Maryland has no standing to make that accusation. So this is a weird case where I think the ideal remedy is not available because there's no injury to claim it. So the remedy of options is less. You can't kill the tax cut, which is why I went down this sort of alternate route of this. What would Gorsuch and Thomas do? This sort of plaintiff-specific remedy that avoids that difficult question. But the 2010 Congress was the Obama position in 2012. You can't have the mandate without GICR. And I think that was the intent of Congress. And that's that you know, but it's an unorthodox position. I accept that. But I agree with California about the 2017. It doesn't look good for Texas.
Yeah, so I think Josh and I are in the same place on the 2017 Congress. I haven't spent enough time with Frost, candidly, to have a view on Josh's theory, though it's an interesting one. I guess I'll just round it out by saying I think here's what's wrong with my view of Texas's position, which is to try to say you should really care a lot about what the 2010 Congress thought. And the whole idea, at least as severability analysis under the prevailing view right now, is you ask how important to Congress was the provision that was unconstitutional? Was the unconstitutional provision really essential to the statute, or was it something that was sort of ancillary, we could get rid of it and the statute would still work the way that Congress wanted it to work? And I think you can't ask that question about the 2010 Congress, because the provision that's unconstitutional is a legal, by hypothesis, if I'm wrong on the merits, it's a legal requirement to have insurance that has absolutely no teeth whatsoever. That's totally different than anything that the 2010 Congress enacted. What the 2010 Congress enacted was something that said, you have insurance or you owe us $700. And the thought was that's really important to give people this financial incentive to have insurance to make the markets work under guaranteed issue and community rating. So there was an interesting debate about severability under the 2010 Congress. But I think it just doesn't make sense to ask how important to the 2010 Congress was this crazy provision that the 2010 Congress couldn't have envisioned and that only came into existence 7 years later. That's the product of the 2017 amendment. And so to me, at least in the conventional sort of severability world, that's why the place to focus is on how important was this crazy provision to the 2017 Congress, because they're the ones who gave it to us.
Yeah, I don't know if it's so crazy. You mentioned a moment ago that there's some people who are subject to the mandate, but not the penalty. Basically, Congress created a version of this statute in 2010, right? There are some people who are subject to the mandate, but not the penalty, which is exactly what exists now. So I don't think it's insane to think what they would have thought of. That's why I make such a big fuss about this colloquy between Roberts, Kagan, and Katsas. They were talking about this small sliver of people who are subject to the mandate, but not the penalty. They were saying, what are we doing with this toothless mandate? That's what they were talking about. There were people. It's a small universe of people, just not many people. So Congress basically created a precursor of the statute in 2010, and that findings that the mandate was essential without regard to the penalty. I don't think it's so insane. Now, I think under modern doctrine, if you look at the 2017 Congress, hindsight's 2020, they figured their game out. The mandate proves to be not very significant. But I think there's some decent arguments why the 2010 Congress may have some juice. But I don't think there are 5 votes for any conservative majority on severability unless they go down the route I propose, which is why the remedy here is probably very narrow, if anything. All these headlines you see on TV, the court's going to kill Obamacare. Oh, come on. That's not going to happen. There's no, unless Trump appoints like 5 new justices in the next 3 weeks or something. Maybe it's possible. I don't know. Right? You don't have 5 votes in that. Maybe you have 2 or 3. Maybe 2.
Okay, so the third question is, rather than viewing the 2017 amendment as an unconstitutional mandate or a full repeal of the individual mandate, could we see it as the same lawful choice the court approved in effect just with different numbers.
Yeah, so what you're asking is, can there be another saving construction? Right? Of course there can. Brian's right? The duty of constitutional avoidance applies forever and ever and ever more. So you basically, it's like an Oreo. You have one saving construction, and then you have another saving construction stacked on top of it. Of course the chief can do it. Well, we find another way to save it, because now, here it is. Roberts will say, this law resembles the law we upheld in 2012, therefore we can uphold it. I don't know. I mean, once you get into this world of saving constructions, I don't have any actual doctrinal argument, right? If you're going to bend over backwards to try to find a way to squint, sort of look at it differently, there's always ways of saving it. I think at some point you run out of runway when you're doing these saving constructions, but maybe the chief can just extend the runway a bit more. But yeah, that's absolutely a way. He can say, you know what? This is close enough to the law we held in 2012. We uphold it. I think what Roberts would probably say is that the mandate's unconstitutional and we just sever it out. We could go home and be done with it in this litigation. I don't know. The chief surprises me every term, and I think there's so much flux this year with the vacancy, especially with the Thomas Gorsuch position. There's not a 5 block here. I don't know where Judge Barrett falls on this, or who knows if maybe no one's confirmed. Maybe we have 8 justices and we just go 4-4. So I think there's just so many unknowns here. It's hard for me to make any prediction credibly. Who's even going to be on the bench November 10th? Who even knows? Well, no, there's no bench. Who's going to be on the teleconference on November 10th? Who knows?
Yeah, I'll just say that I'm also completely out of the business of making any Affordable Care Act litigation-related predictions. So I also won't hazard a guess as to where we'll land.
Yeah, agreed.
We've got 2 more questions. The first kind of follows from the last one. I was wondering whether there are instances where Congress exercises its Article 1 taxing power where there isn't any sort of payment involved. So wondering, for instance, about the Fbar Disclosures, which require people to form bank accounts of a certain value to disclose them, even if they don't derive any income from them. Does that derive from the taxing power? And sort of by analogy, could you think about as your job?
I've never heard of Fbar. I have no idea. I'm sorry. Brian, do you know anything about this?
I don't know Fbar in particular, but I think the sort of broader question of it gets to the theory of, if you accept my understanding of the mandate, that it's not a legal requirement to have insurance, it's just a provision that says you have to have insurance or you pay a tax of $0. I think there are some, California's first argument about that is that you don't need an enumerated power to enact a law that has no effects. So the case is sort of over at that point. There's sort of a backup that says, no, I'm not buying that. There's still this text in the U.S. Code, and we need to attach some constitutional power for Congress to be able to enact that. And I think there's some debate way in sort of the weeds of the briefs about whether the taxing power might be that authority. Even though this provision no longer raises revenue, could it nonetheless be a valid exercise of the taxing power? And my take on that, I haven't spent a ton of time with this, but my take on that is, yes, that does strike me as plausible. The idea being we have this structure of a tax provision that we have on the books before. We've decided to zero it out now, but we've left it in place so that a future Congress, if it wants to tailor the amount, can tailor the amount. That seems to me like plausibly unnecessary and proper sort of adjunct to the taxing power. But again, I don't think it's gotten a ton of attention.
Is a law that does nothing rational? Texas actually raises argument. Does a law that does nothing have a rational basis? Does nothing. I mean, forget it. No due process arguments. I'm done. We're no Lochner for today. We're done. All right.
The last question is a little bit further away from this case, but it's asking what's likely to happen to some of the Trump administration regulations concerning the ABA. Biden is elected in November.
The ABA or the ACA?
I'm sorry, the ACA, sorry. Yes. I'm thinking in particular of the exception from filing a form for employees to receive contraception coverage that was upheld in the Little Sisters of the
Oh, okay, yeah. Okay, so we're pivoting to another Obamacare case, which also have to write back for my millionth book on this stupid topic. Another book on this. So the ACA's contraceptive litigation has been going on for, I think, 7 years. It just seems like interminable forever. It's almost like purgatory. At the start of the Trump administration, the HHS tried to create basically an exemption that if any group has an exemption, they would just be exempted. There was no accommodation. There was no way of getting the female employees contraception. It was a carve-out. The Supreme Court sort of upheld the regulation, but if you read the Kagan concurrence, they basically said there's other ways of challenging it. So I think this goes back down to the district court to consider what's called arbitrary and capricious review, which is a more kind of rigorous standard. If Trump wins, I guess we'll keep litigating this for a couple of years. If Biden wins, they may try to rescind the regulation. Now, this is a huge topic, which Brian and I can talk about for hours. What is the fallout of the Daca decision? Yay, the Dreamers got to stay. Well, yeah, but there's some doctrinal stuff going on there too. The Chief's decision, I think, makes it very difficult for a administration to reverse a prior administration's decision. Roberts applied what's called State Farm. That's a very rigorous, hard look on these sort of reversals of policy. I'll leave others to argue whether Roberts amplified it, but it's now, I think, the court's policy to be skeptical when the government reverses itself. So stuff that Trump did, if Biden tries to undo it, it could be held up in court for years. And basically, the same way we're stuck with all these Obama policies after 4 years, Biden could be stuck with all these Trump policies after 4 years, unless the court changes direction again, in which case, who knows. But I think the Daca decision may seem like a blessing for progressives today, but if Biden wins, they're going to hate it really quickly. The Chief's decision, I don't like it. It makes it very hard for an agency to change course because there's such an exacting level of scrutiny that can be played Monday morning quarterback style to second guess. Brian, what do you think about the Daca case? Forget the merits, but just the doctrinal change of the Chief's opinion.
I think it's an interesting question. I haven't focused on it a ton, and I'm sure the parties challenging changes it in positions across administrations will trot it out. I don't know if that's one of those decisions that will develop into a real change in the doctrine, or whether that's going to be was driven in part by some things that are unique to the Daca case, and you won't see courts extending that same sort of level of scrutiny across other areas. But yeah, I agree. The short answer is I think the contraceptive coverage case is still pending now, will presumably still be pending after the election. If the Biden administration wins, the posture will be the same, that it'll be suddenly inherit the defense of these Trump-era regulations. I lived through a version of this in the last changeover in administrations, and what basically tends to happen is the DOJ will say to the courts, new administration, the agency's looking at this policy and thinking about changing it. Would you stay the litigation for a little while, and while the agencies figure out whether they want to stick with the regulations or make changes? But it could be quite a messy administrative and judicial process to work out.
Thank you.
Great. Thank you so much for joining us today. This has been a great event and a great way to set off our year. Thank you all the audience members for being here also and for your questions. Please join us in 2 weeks. We're hearing from Professor Green from the University of Mississippi and Professor Myler from SLS about the oath clause and constitutional indexicals, how we should interpret those from a revisionist perspective. Thank you both so much, and have a good day.
Thank you so much.